Hi, what happened to your eye?
My ex-boyfriend.
Oh, I'm so sorry. I hope you're giving her information of how to take care of that.
I've talked to her about that as, and Your Honor, we have a sensitive subject that we need to bring up today as well.
All right. If you all will meet me in the hallway, I'll talk to you in the hallway. Just have a seat.
Thank you.
If you'll have a seat, counsel, and I'll speak to attorneys. Nice to meet you too. So you're the father?
I am.
Okay. All right. So this is what I always tell parents. And I used to be a defense attorney, so I know how it is with parents. When parents have children, their child can be 30, their child can be 40, that's still their baby, and they want to be involved. And it's especially true when you have a child who is young, 17, 18. But here's the thing, in this world, they're all considered adults.
Okay.
And when they have an attorney or something, the relationship is between them and their attorney. I used to have to tell parents all the time because sometimes the parents would hire me. And I used to have to sit down with parents and say, hey, you've hired me, you're paying me, but that's the end of our relationship. You can't be a part of discussions I have with my client because guess what? I would tell them, if you're a part of discussions I have with my client, then there's no attorney-client privilege. And you know what ends up happening with that? When there's no attorney-client privilege, guess what? You can be called as a witness. Anybody who's in that room having a conversation, it's all fair game. They can be called as a witness. And maybe sometimes there is something that maybe a client wants only their attorney to know, and they don't want other people to know. But when parents are in the room, guess what? That all goes by the wayside. And sometimes we have to let our children go and let our children be adults. So on this side of the fence, I would always tell parents, it's great. I need you to be supportive. I need you to make sure that my client, your child.
This right here is a huge moment. The judge is explaining one of the most important rules in criminal defense, attorney-client privilege. If a third person, even a parent, sits in on those conversations, that confidentiality can vanish. And once it's gone, the prosecution can potentially drag that person into court as a witness. That's why defense lawyers guard those conversations like a vault.
Be in this conversation and you cannot be talking to your child about what happened because guess what? You can be called as a witness. They wouldn't listen to me. And so when it came time to do a plea bargain agreement, the parent is in the hallway, and I can tell you this because they were in the hallway shouting, so everybody heard. So it's not confidential. So they're like, I want my child to do A, B, and C. And you know, I told them, I said, that's your child's choice. Because guess what? If your child chooses A, B, or C, and if something ends up happening and they end up going to prison, the judge is not going to say, you know what, your child only chose A, B, and C because of you, so we're going to let you suffer the consequences. You understand?
I do.
And for some reason, with attorneys, people assume that being an attorney is easy and being a doctor is so much differently. Because if you go to see a doctor and you get a second opinion and a doctor tells you, oh yeah, your child needs a heart transplant, or oh yeah, we need to take the appendix out. A parent doesn't go to that doctor and say, well, I want to look at everything and let me just tell you how I think this appendix should be taken out. The person depends on the doctor, that the doctor knows what they're doing. And that's the same case. That's the same situation with these cases. And everybody needs to understand that. Cannot be crossing lines. Does everybody understand? Understand? All right. So that's the way it's going to be. So this is what's going to end up happening. We are going to come back. And we're going to come back on June 27th. Counsel, is that enough time?
Yeah. Yes, Your Honor.
All right. So we're coming back on June 27th. And let me just tell you the way this court is run.
Well, you say 27th or 22nd?
27th.
I am double booked. I've got a hearing on the 27th.
Okay.
But
All right. We can bring it back on the 24th.
yes, thank you.
All right. So we're going to come back on June 24th. This is the way things run in this court. I make sure that everybody has the discovery. So when the defense counsel and everybody tells me I've received all the discovery, next thing I do, I require the state to tender an offer to the defense. And the defense has an ethical and legal obligation to tender that offer to their client and tell their client what the consequences are of the offer. Then I give everybody a plea deadline date because I want people to think about whether they want to accept the plea or not accept the plea. If they decide not to accept the plea, when I give them the plea deadline date, then that plea deadline date has expired and the next setting is going to be a jury trial. And if somebody after that plea deadline date has expired decide, oh gosh, I don't want to go to trial, the only way I'll accept a plea is for good cause. Otherwise, they'll have to plea open to the court. All right, everybody understand? Any questions, Dad?
I do have one
Sure.
question, Judge.
Yes.
When your child has a serious, persistent mental illness and a developmental disorder, and that is recognized,
You can feel the tension building here. The judge isn't attacking the parent. She's drawing a hard legal boundary. In criminal court, good intentions can still cause serious damage, and this father clearly wants to help, but the court is warning him that stepping into the lawyer's role could actually hurt his daughter's case.
That is something for her attorney to address. What you should do as a parent is turn information over to the defense attorney if you think it's something that she needs to know or is something that her client wants her to know. You understand? So here's the thing, you got to cut the string. And when I say cut the string in the court, I mean court the court as in your daughter and her attorney need to be able to have conversations in private. Now, if her attorney wants information from you, then the attorney will ask you, say, hey, I need some information from you. These are records. Maybe I need these records. I'm trying to get these records. Do you have these records? This is something that I want to view. That's completely up to the attorney. But what you're telling me right now and quoting code sections to me, guess what that tells me? You're trying to be an attorney and you're not an attorney. Did you go to law school?
I didn't go to law school.
So there's the thing. People think that they can read penal codes. They can read the code of criminal procedure and that's it. And not to step on anybody's toes, but for criminal law, when you're practicing criminal law, you know what your Bible is? Your Bible for your profession is this book. And you see how thick this book is? And so if I were not an attorney, guess what? I would see one section and I'm like, oh, that section says that. D is for done. But that's not the way it works. This entire code, guess what? You may read something in this section and still you have to go to this section because it all relates to it. It's similar to the Bible. And let me bring the Bible up for you. Some people will just read one section of the Bible and guess what? When you read that one section, that same person who is listed in that one section, there's somebody else in a different book that has something about that person in the other section. So when you just come away with one part of that section, you think, oh, I'm done, and you're not. And that's why you have to study this forward and backwards. And how many years have you been an attorney?
Over 20, and I'm board certified in criminal law.
All right. Over 20, board certified in criminal law. So when people are throwing code sections out to her, let me just tell you, I know her. Every attorney in here knows her. And all attorneys know each other because when you've been in Bexar County practicing for over 20 years, people know you, people know your work. What I can tell you is she would not be board certified in criminal law if she didn't know this book and know the updated part of the book. And what do you do for a living?
I have been the president of an international Fortune 400 company in Mexico City.
So let me ask you this.
Yes.
How would you feel is if you are doing that job, and how many years have you done that?
20.
You've done that for 20 years. and I just walk into your place of business and I'm telling you how to run things and telling you what the law is about something that you've been doing for all your adult life. Maybe you wouldn't take offense about it, but I guarantee you when I left the room, you know what you'd probably say? Who does she think she is? She doesn't have a degree in this. She hasn't even worked in this field and is trying to tell me how to do it. And for me, that's with any job. For example, I wouldn't go to McDonald's and tell them how to cook their fries. I haven't cooked their fries. I don't know how to cook it. I would not go to a contractor and tell them how to pour concrete. I may think I know how to pour concrete, but the little things I know about pouring concrete, you have to have it at a certain temperature. Otherwise, it's going to crack. You have to mix it appropriately. That's why when you see people out here mixing all their concrete with quick concrete, sometimes it doesn't go right because there are certain things that experience, knowledge, and education treat you about it. So here's the thing at the end of the day. At the end of the day, this is her attorney. From what I've seen, it appears to the court that she's following through on all mental health issues, if there are any. You know why I know? Because I put in here, refer to mental health court. And I know that she's been working on doing that. That's why it's in here. Otherwise, it wouldn't be. And you know how I know that? Because she requested it. So when you come to me about the code of mental health, I already know she knows about that because otherwise it never would have been requested. Sure.
And of course,
As long as you're not quoting the law to me.
I won't go the long, Your Honor.
Okay.
Of course, she did go to mental health, and that's where we discussed, and that's the absolute right place to be. Just a month ago during a suicide attempt, I said I really finally have insurance, and I'd like to get inpatient care for her because it's a very serious issue.
Okay.
And I was correct. No, let's hold off until we can get.
So here's the thing, though. The advice that she's given your daughter and the advice that maybe she's given you, that's from her legal perspective, and she's trying to protect your daughter's.
Quick question for you watching. If you were the parent here, would you step back and trust the attorney, or would you keep pushing to be involved? It's a tough emotional call, but legally, the judge is making it crystal clear. Once your child becomes an adult in the eyes of the law, the attorney answers to them, not the family.
She's going to accept the offer, not accept the offer. And either we're going to be in jury trial or we're not going to be in jury trial. That's where we are. But I will tell you this, whenever you're meeting people and you're meeting people in their profession and you want to talk to them, don't quote them things about their profession. I know that she's not going to take it as a slight, but people tend to not like that because people pay more what the cost of a mortgage for their degrees, and they spend a lot of time, experience, and knowledge doing what they do. And I don't know of any defense attorney who would purposely try to lead their client down the wrong path. And I've never seen her try to purposely lead her client down the wrong path. And just my experience of a judge with her, I've never had to tell her what the law is. Okay. All right. Is there anything else?
There is.
Yes.
My client had a mental health evaluation that her father has possession of and is refusing to relinquish, from my understanding. I would like to get that today.
All right. So here's the thing. I can't force you to turn over things to her, but get this. She needs information in order to represent your daughter, right? So that's what she needs in order to represent your daughter. Whether you want to turn it over or not, that's completely up to you. Here's another thing I would always tell my clients and my clients' parents. This center of the courtroom, which we call the well of the courtroom, is a minefield. Your child, I am directing them on where to walk in this well. That's a minefield. I'm behind protected glass. I'm going to be just fine. But when I'm telling them to turn right, it's based upon all the information that you've given me or withheld from me. And when I tell them to turn right, I would always tell them they have no choice. They're going to go right. Now, when they turn right because of some information you haven't given me, and I'm going by the information that I have, is there going to be an explosion? If there's an explosion and it's because of some information you had that you didn't give me, that's all on you. So if you or if people care about their children, this attorney, it's confidential. So if she receives something, guess what? It's confidential. It's something that she's received. Maybe it's something she wants to discuss with her client or not. It's not something that she is going to turn over to the state unless that's something she thinks should be done. So if you want to hold on to that, then that's up to you for holding on to it. But if you say you want to help your child and she's telling you she needs that information, I mean, what do you think she's going to do with the information? You know?
Well, I would say, I'd love to hear what her understanding of Michelle's mental.
Here's the thing.
Yeah.
I want you to internalize what I'm saying. She doesn't have to talk to you. You're not her client. What she's telling you is you have information and I'm assuming you want her to see the information. So either you want her to see it and study it and give it to her or you don't. If you don't, that's fine. I can't legally force you to turn that over to her. But what I'm telling you is if this is a child and you say you love your child, which I'm assuming you do, I've just told you the information you turn over to her is information you given to her. Her medical records are confidential. She's an adult, so I don't even know why you have them in the first place because she is an adult. Those medical records are her medical records. They are not yours. She is not a child in the eyes of the law. So if you have something that would help her attorney represent her better and you love her, you probably should turn it over. The end. That's it. The end. All right. So either are you going to turn that over to her or not? That's either yes or no.
I'm going to give it to my daughter. If she wants to, it's a client, privilege between the two. And if she wants to.
All right. So just hand that over to your daughter now then. All right. Is there any other documentation that are medical records that belong to your daughter? And when I say
And here's where the father tries to shift the conversation, bringing up mental illness and even quoting sections of criminal procedure. But watch what happens next. Judges hear legal arguments every single day. And when someone without legal training starts citing statutes in the courtroom, it rarely goes the way they expect.
can't give her her documents and then say, oh, I don't want your attorney to have it, or I don't want this to occur. You need to be a part of her having great mental health. And the way to do that is not put stressors on her. And don't put stressors on her by interfering with her relationship with her attorney. Because guess what? This atmosphere, being on the criminal side, is already stressed enough, whether somebody committed an offense or not. Can you imagine the stress that people have because they think maybe they're going to prison? People in the box, guess what? They're over there. They're brought over from the Bexar County Jail, not on bond, can't make bond or something else. Even though you may say, oh, my daughter's not like those people, or my daughter doesn't have criminal history. Guess what? Even if there's somebody over in that box who's been to prison before, guess what? Their heart is still beating fast because they don't know if they're going to go back to prison or not. So this is a stressful situation for her. Don't make it any more stressful. You understand? All right. Thank you very much.
Thank you, Your Honor.
You're welcome.
I reset to the 24th.
Yes. All right. I'm going to take up these three cases. Then we're taking our break for lunch. Appropriate places.
Yes, ma'am.
Did you understand you're charged with injury to the elderly, bodily injury? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up these rights and enter into a plea?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison, and up to a $10,000 fine.
Yes.
Off the record for a moment.
Excuse me. Oh,
No, it's not a problem. This system is new and it's taking us a while, but we're going to be just fine. We're back on the record. Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Ms. Holmes, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
I'm sorry, what?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is recommending deferred adjudication. They're taking in consideration 2023 CR 8418, and there's to be restitution of $3,700.85 to John Ripley. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 150 hours community service restitution, no contact with John Ripley or Feather Point Road, San Antonio, Texas, 78233. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charge, how do you plea?
No contest.
State, any evidence?
No objection, Your Honor.
And state, have you conferred or spoken to the complainant?
Yes.
All right, thank you. You may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did
Yes.
you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client has obviously, since this case occurred back in July of 22, she's obviously stayed out of trouble, Your Honor. She's been to court. She is going to school. She's becoming a business, nevertheless.
Esthetician.
Currently she works as an esthetician, which is my understanding is skincare. And that's what she does for a living. But she's also going back to school to get her degree in business administration. She has 2 children, a 15-year-old, a 17-year-old that she takes care of. And this is a difficult case, obviously, for her judge. This is a true no contest plea, and this is what she believes is in her best interest. She wants to get off probation as soon as possible, do everything she can, Your Honor. So we just ask you to grant this and get closure on this.
All right. So, Ms. Holmes, you understand when people ask you to leave their property, whether you think you're being evicted legally or not, it's always best to leave and then just handle things civilly. So if this were a case where you didn't think you were being evicted properly, all you had to do was, you know what? I'm going to file a civil case. And it appears that it is not a civil case that would be filed in district court based upon what the amount is. So you would just go to one of the JP courts and you just file it. And there are plenty of people who file that every day. And that's how you solve that, as opposed to coming here. Now you have all of these extra fees and you have this. You understand?
Yes, ma'am.
So, of course, I always have to ask this question. The piercings underneath the lip, were those painful?
No, ma'am. I
Okay.
didn't get them at the same time either. I got them over a period of time.
So what order did they did you get them? What was the first one?
I had got this one, I was like 16,
Mhm.
and I got this one, I was like 19, and then I just got this one, and it's just compliments when I smile.
Oh, okay. I'm always wondering. And the tattoos, what are the symbols for those?
It's really not too much no symbols, butterflies, music symbol. I play the piano,
Oh, wow.
Bible verses. I grew up in the church.
See, I always wanted to play the piano, and I was going to take it as an elective in college because everybody's like, it's an easy elective. Okay, I'm in a class that's supposed to be for beginners. Everybody in there had a piano at their home and had been playing forever. They were truly taking it as, yes. I couldn't even answer because our professor would say, in order to answer the roll call, you had to play the note he wanted you to play. I'm like, yeah, I'm out of
Drop
here.
that class.
I dropped it, but I dropped it before they were going to give me a W.
There you go.
I saw the writing on the wall before the end of the week. I was like, no.
Judge, as you know, YouTube that want to learn piano, YouTube will teach you immediately.
All right, we're going to see. Well, don't put professors out of business. All right, so you're currently employed. Okay, so this is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. Take in consideration 2023 CR 8418. And state, do you have that? There's going to be regular reporting by Zoom. Thank you. On the person.
Thank you.
There's going to be regular random UAs. I always have to tell people who are new to probation, when you're on probation, you're not allowed to drink alcohol at all, even at your own home. You're not allowed to do marijuana, even at your own home, because what that's going to result in is a positive UA. And people think these are my rules. These are the rules that the legislatures have put in place. So if you're UA today, is everything going to be fine? All right. What's going to be in your system? All right. So we're going to do random UAs and we're going to test for levels. So those levels need to start going down. You understand? And do not, if they file a motion to revoke because your levels are increasing, do not come back to the court saying you were around people who were smoking because you have children. You shouldn't be around people who are smoking because it gets in your clothes and children end up smelling like marijuana. Their clothes smell like marijuana. And then children who are at school tend to tease them. And we don't want that. There is to be 150 hours of community service restitution.
May I speak to that, Judge?
Yes.
Is it possible if she can show semester grades going towards her business administration degree that can satisfy some of that community service?
I was just about to say.
Thank you, Judge.
Thank you.
ESPN.
The community service hour. Yeah, we're here. The community service hours will be waived once she provides proof of her BA. And honestly, you should be able to finish that, hopefully, before your community supervision has expired. But if you show the court that you're actually taking classes, and when I say take classes, your attorney, no, I will mean this, not just one class a semester. You understand? And I understand that you work. I understand that you have children. So for you, it's going to have to be at least 4 hours a semester. And that's not full time. For this court, at least 8 hours is full time. But because of everything that you have going on in your life, probation, she needs to do at least 4 hours per semester. There's to be anger management. There's to be no contact with John Ripley or the address on Feather Point Road. And there's to be the restitution amount of $3,755.85 to John Ripley. And there's to be field visits one time per month for 2 months. Probation, is there anything else? Thank you. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors.
And Judge, was the fine probated? Is that something I need to address? Or?
There was no fine asked for. You're welcome. Probation, anything else? Is there anything else you need from the court to be successful? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Off the record, in this court, to be successful in probation, communication is key. If you have an issue, let your probation officer know about it. If you feel as though your probation officer isn't addressing it, you can always come back to the court and we'll take it up. All right. Do you have any questions? All right. Good luck to you.
Thank you, Judge. May I be excused?
Yes.
Thank
Once she talks to probation.
Yes.
Luis De Leon.